Will an ALJ offer a closed period of disability if they believe that there's a period that exists? You're not going to like this answer, but I'm going to go ahead and give it to you blunt. It depends on the judge. Under the regulations, in order for you to be found disabled, you have to be not doing work, have a severe mental, physical, or a combination of both impairments that's lasted 12 months or more that's kept you out of work. They have to determine whether you meet the listings from medical listings. That's the medical listings that's listed in the listings of medical conditions. If you don't meet those criteria, they want to then know, are you able to go back to do any of your past work based on your residual functional capacity? And if you can't do anything you used to do, can you do anything else? And the magical window is 12 months. This is a good question that I have come up, because technically what's happened is, if the judge looks at your file and it looks like during this window, let's say there's a 2-year window, and the judge doesn't believe you were disabled for 2 years, or doesn't believe you're disabled ongoing, but the judge believes that there was a 12-month period of time, in theory, they should find you disabled for that period of time. So the answer to your question is, yeah, that's what it should happen. Does it always happen like that? No. I'll just be blunt. It doesn't always happen that nice. A lot of things come into play. It could either be the judge, if you're a representative, may say, I think we got a closed period here, or the judge may issue a partially favorable decision where they basically say, here's a closed period, I don't think you're ongoing. A lot of things could come into play, but the short answer to your question is this. If Social Security, or if a judge believes that there is a 12-month period of time, just a definitive 12 months, where you are unable to work and unable to do any other work because of your conditions, in theory, they should grant a closed period. Again, as I say, doesn't always happen that way, but it's important for you to recognize that it may. Now, I will tell you this, and I'm always a pooter, well, I don't want to say a pooter, bad word. I'm always one who encourages the use of resources and so forth. If you're not sure when you're looking at your case, because I've had this happen where people come to me and they'll say, I applied for disability benefits, but I'm feeling like I'm doing much better. And that what they're basically telling me is closed period. But they don't know how to necessarily present that to Social Security, or even appropriately present that to the court. If you're not sure, I know I've seen a couple of posts on here when they're like, oh, Attorney Reeves, he's over here self-promoting and granting for himself. He's an attorney. He's trying to make money. And I'm like, you know what? I'm going to tell you like I tell everybody else. If you think you can go in there and appropriately make an argument to the court why you should have a closed period, go for it. But if you don't, and this is for the people out there, I'm not talking about the people who have a good grasp of this and think they can handle it on their own, knock yourself out. If you think you want to roll the dice, knock yourself out. What I'm telling you is that if you don't feel comfortable about what you're doing, and if you're not sure, please look for somebody to help you out. Don't go in blind, don't go out in blind and crazy. If you're not sure whether or not you have a situation where a closed period is appropriate, or more importantly, if you're not sure how to go in and argue for a closed period, look for some assistance. Try to find a representative in your area, whether it be an attorney or a non-attorney. Don't go in there blind and mess up your situation. But the short answer to your question is yes. Social Security should take in consideration a closed period if they believe that you have a specific 12-month period where you were unable to work due to your